Welcome to the latest episode of International Law Chats, or ILC for short, a podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope you can join us each month for a new episode. I'm Chiara Giorgetti, a professor of international law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy. I'm hosting solo today. Today, we're discussing one of the most significant developments in international economic law in recent years, the reform of Investor-State Dispute Settlement, or ISDS, currently being undertaken through the United Nations Commission on International Trade Law, also known as UNCITRAL, and specifically in Working Group 3. The ISDS system has long been a central feature of international investment agreements, allowing foreign investors to bring claims directly against states through international investment arbitration. At the same time, it has faced growing criticism concerning issues such as consistency and predictability of decisions, cost and duration of proceedings, arbitrator independence, transparency, and the balance between investor protection and states' regulatory autonomy. In 2017, UNCITRAL entrusted Working Group 3 with a broad mandate to identify concerns regarding ISDS and to consider possible reform options. The process has now been underway for several years and has generated a number of proposals ranging from targeted improvements to more structural changes. This is actually a topic I follow very closely. I'm especially interested in, also because I participate in the negotiation on behalf of San Marino. Today, we will explore how this reform process began, how UNCITRAL Working Group 3 operates, the main reform proposals under discussions, and what has been achieved so far, and where the progress may go next. I'm delighted to be joined by three distinguished guests. Joubin-Bret is the Secretary General of UNCITRAL and the Director of the International Trade Law Division in the United Nations Office of Legal Affairs, which functions as the substantive Secretariat for UNCITRAL. Shane Spelliscy, who is Assistant Deputy Attorney General of Canada in the Department of Justice since 2025, and prior to that was Director General and Deputy Legal Advisor in the Trade Law Bureau of Canada. He's also the Chair of Working Group 3. And Natalie Morris-Sharma, who's Senior Director and Senior State Counsel in the International Affairs Division at the Attorney General's Chamber of Singapore. She is a Rapporteur for Working Group 3. Anna, Shane, Natalie, welcome to International Law Chats.
Thank you for having us.
Thank you.
Anna, thank you for coming again. Let us begin with the origins of the initiative. Anna, could you take us back to the discussions that led UNCITRAL member states to place ISDS reform on the agenda? What were the concerns that prompted the creation of Working Group 3's mandate?
Well, thanks, Clara, for this question, which is actually quite ironical to ask me about that, because I arrived at the time when the mandate was given to Working Group 3. But it's not ironical. It was rather serendipity that I could be there at the time when this important work was brought to UNCITRAL. In fact, it's work and concerns that had been voiced for many years, and even some of the most prominent reform elements that we have currently on the table in Working Group 3 date back to my time in UNCTAD, where we had a long work on establishing an advisory center for developing countries of Latin America to help them face investor-state disputes, and where we also, and I remember that very fondly, I used to be hosting what we called fireside chats to discuss different avenues for ISDS reform, including a very interesting one that I co-organized with David Caron at that time at Don Donovan's residence, which was under construction. So we were sitting in a construction site discussing an appellate mechanism, and that was in 2007. So just to give you this background, which is more personal background, but which places it into this general backlash that was happening against ISDS, mostly against arbitration, against ICSID at that time. Several countries were walking out of ICSID, slamming the door. The European Union woke up to the TTIP negotiation, the transatlantic partnership on trade and investment. That also brought about a lot of backlash. And during these early 2000, the years 2000, there was a lot of thinking, a lot of discussion about what to do about investor-state dispute resolution. And in 2010, France and Germany put together a proposal to establish a court. And this court that they called a multilateral investment court, so this also resonates with what is being discussed currently in the working group, was on the table, and there was no actual host for this initiative. At the same time, UNCITRAL had worked a few years earlier with success on transparency in investor-to-state arbitration. The idea being that was one of the main concerns for most of civil society, that you didn't know what was happening in the context of ISDS cases. And in spite of it being mostly paid out of taxpayers' money, so all of this brought about these transparency rules, the Mauritius Convention in UNCITRAL. And then the third element of serendipity, if you want, was a study that was commissioned at that time to SIDS, the program of the University of Geneva that is led by Gabriele Kaufmann-Köhler, who's a very, very well learned and known personality in the area of investor-state disputes, and who suggested that the approach of the Mauritius Convention and of this remedy to the investor-state dispute resolution, this lack of transparency, this opacity, could also be applied to other types of reforms, particularly to the establishment of a court. And so this is how this proposal was made to the UNCITRAL Commission in 2017, supported by the SID study, supported by this initiative of the EU and its member states to reform in depth, and actually also supported by other member states and by an equal share of observers, of NGOs representing civil society, but also representing investors, that there were a number of defects in this ISDS system that could be remedied, or that would warrant to be remedied. These were mostly around cost, and that was, of course, shared equally by the states, the defending states, and the claimants, the companies that are bringing these claims, the duration of these cases, the enforcement of these cases, which systematically were going, or almost systematically were going for annulment, even if the annulment window was very small. The legitimacy and the way of operating of the decision makers, mainly the arbitrators, but also their assistants. And this resulted in a legitimacy issue for the entire system. And that arrived on UNCITRAL's table in 2017, and I arrived a few months later.
Thank you. You arrived at the right time. You're right. Serendipity. Thank you really very much for this excellent introduction. And Shane, let me turn to you now, and let's focus specifically on Working Group 3 and maybe how it works. The Working Group 3 process has involved a very large number of participants and from very different perspectives. Could you explain a little bit how the working group functions in practice? How does UNCITRAL Working Group conduct the negotiation, and how the proposal discussed is eventually reflected in the work of the group?
Sure. Thanks, Chiara, and thanks for the opportunity to talk with you and everybody today. I think one of the great strengths of Working Group 3 is indeed the breadth of its participation, and the number of states coming from different perspectives and really different lived experiences with ISDS. And I think that gives an overall perspective to the work that is different than sometimes you see when it might just be one group of states, whether they're respondent states or investor states involved in discussions of this. And it makes the working group, in my view, a truly sort of unique opportunity to perform this. It does present challenges. A working group operates by consensus. And so what does that mean? It means that when we look around the room at the states participating, we seek to reflect the view that can be accepted by all in terms of decisions. It requires compromise as a result. I often say that I only know it's a right decision when everybody is equally unhappy with the way that it's turned out, because that means that there's a compromise. But how does that compromise work? How does it come out? We often have very robust participation. And when we look at the flags that go up in the room, whether they be the old style physical flags in Vienna or the names that appear on our list in New York, we simply go through and we go through delegations in the order in which they raise their hands. That includes both states as well as observer delegations. And we try to be as open and as transparent as possible. There are times, of course, when we are running out of time and we will focus on the views of states. And when we are looking for consensus, it really is the views of states. But we look often broader for consensus. It's not just the member states of UNCITRAL, which is only about 70. It's every state that's in the room, as they all have a unique perspective to bring. One of the things in terms of how the negotiations go, and one of the things I've been really pleased with over the years is member states do, in terms of the states of the working group and observers, really do intend to engage with proposals in a really serious way. So it's not a situation where states come, they have just a prepared statement, and this is what they read, and sometimes there's not that back and forth in some international organizations. Here, as a technical working group filled with experts in this area, whether they be lawyers who are practitioners, whether they be treaty negotiators, whether they be academics, we're really able to engage in detail and in substance with what has been proposed. And so you will see text proposed that will then be negotiated, specific words, and a negotiation happens a lot more, I would say, in a sense, like a treaty negotiation, where there might be fewer states at the table, in that we try to move text forward, listening to a proposal, responding to it, trying then to find consensus. And of course, as I say, that's not always easy. But I think one of the things that really does work at UNCITRAL is, we hear proposals from so many different perspectives, so many different stakeholders, whether they're states, observers, and we get a significant degree of participation. So much so that often it's easier to think about who hasn't spoken on the issue, as opposed to think, you think, is there anybody left? Or we've got everybody's viewpoint here. And that is what really sort of allows us at the end to try to, working on the desk with Natalie, with Dana, with Jay, the secretary, and Neil now, to try to craft that, okay, this is what we've heard. So many different viewpoints they've engaged. This is the path that we can try to chart forward and try to reflect what that consensus is.
Thank you very much. It's very interesting. And in fact, it's always been it's very inclusive and dynamic process. As you say, it's very interesting to hear your perspective. Now let's move on to the substance and talk about some of the reform discussions that we are having. One of the distinctive aspects of Working Group 3 is that it has considered a range of possible reforms, from incremental improvements to much more systematic changes, rather than just starting with a single predetermined model. Natalie, could you briefly guide us through the main categories of reform options, like the landscape of proposals or menus of option, if you will, that has emerged from Working Group 3 discussion so far? Broadly speaking, what are the main categories of reform that has been considered so far?
Certainly, Chiara. I think for one, I should just acknowledge that the proposals, of course, to have a permanent investment court has probably garnered the most press coverage over the years. But the potential solutions that are being developed at UNCITRAL and the working group are much more wide-ranging, as you've acknowledged, and they're not limited to proposals for a wholesale replacement of arbitration. In 2017, the mandate that was given to the working group was a broad one to develop possible reform models for ISDS. And I think one of a very useful reference point is something that we developed in 2021, which was a work plan that charted out the working group's intended work. That was for resource requirement purposes, but it does give a good visual menu of our reform efforts. And at the time, we classified the work into 8 tracks. So for the more what you've called systematic or systemic reform options, we have the multilateral investment court, the effort mechanism, selection and appointment of arbitrators. And then we have some work streams to implement more targeted changes. And these would be the code of conduct, which has already been done, and the procedural rules reform, which is currently underway. And then we have a couple of streams that take a more holistic approach to reform. So ADR, alternative dispute resolution and mediation, dispute prevention, also the Multilateral Advisory Center, for which the statute was recently adopted by the Commission just earlier this month, or last month by the time this airs. And to wrap it all up, the 8th work stream is the multilateral instrument to implement reform. So that takes us kind of from one end of the spectrum all the way to the other.
Thank you very much. And for the listeners who are interested in learning more, may I recommend also the website of UNCITRAL that really contains a lot of background materials, and of course, it's updated regularly. Let's delve into some of the reform, some of the specific reforms items that Natalie has mentioned. And Anna, one question to you. One of the major achievements of the reform process has been the adoption of the codes of conduct for arbitrators and judges in international investment dispute resolution. It has been described as the low-hanging fruit and has become the first instrument to be adopted by the Commission. I had the privilege of working on some of the early drafts while I was a scholar in residence at ICSID, so I'm especially looking forward to hearing your reflections on the code and how it has worked in practice, how it is working in practice. Could you explain very briefly the importance of this instrument, and also what were the issues that it was designed to address?
Thank you very much, Chiara, and thanks for mentioning indeed that we started working, when we started drafting, we worked on a draft that you had prepared when we worked jointly with the ICSID Secretariat, our friends from across the pond. Yes, indeed, this code of conduct is the first text that came out of Working Group 3. It was, as you said, also a so-called low-hanging fruit, but it wasn't so low-hanging that it didn't require a lot of negotiations and deliberations. And the interesting aspect of this code of conduct that since it was the first element that the working group was, the element of reform that the working group was working on, it was really a way of testing its negotiation and deliberation dynamics. So it was quite useful and there are lots of lessons that can be learned from the way the negotiations on the code of conduct happened. What it was meant to really target some of the major concerns that arose from the nomination and the conduct of arbitrators, some based on strict factual defects of the system, and others more on perceptions, particularly some concerns about the fact that it was perceived as a small club, where a lot of the so-called double hatting was taking place, where one day you could be an arbitrator and the next day you could be a counsel in a case that was basically addressing the same issues, because it's always the same legal issues that are at stake in investment disputes, that there was no diversity, and also taking advantage of this work, of this element of reform, to bring in more guidance for arbitrators on disclosure. And I think that is really what stands out in this code of conduct, is this very clear guidance that is given to arbitrators at what they should disclose, which is not meant to raise more challenges, but which is really meant at bringing in a sort of self-discipline into an area which was operating without ethical rules or ethical codes, which doesn't mean to say that it was not an ethical profession, but at least there were no concrete rules, no concrete guidance. So you're asking me about the impact. I think the code will at some point be included into this multilateral reform element, and by being included, become applicable to existing treaties. But most importantly, it's being now included into treaties. It's being proposed by arbitral institutions to be used by the parties. And very interestingly, it is also now increasingly consulted, and I would say even consistently consulted by arbitrators. When they receive a request for an appointment, the first thing they will go to is the code of conduct and say, what should I disclose? And where are there issues that should, from the outset, tell me, rather than stepping down later in the process, why don't I just pass on this proposed arbitration? So I think that's really the merits. It's first that it has really allowed the working group to get into the negotiations on a very concrete text. It was not a major reform that could not be achieved, but rather something very concrete. There was a lot of appetite for this code of conduct among the member states, but also the other observers. And the second aspect is the practical, the usefulness of this code that has a long life ahead of it.
Thank you very much, Anna. Shane, let's just move a little bit and look at a systemic, or more structural systemic proposal of change, which has, as Natalie mentioned, has gathered a lot of attention. And really one of the most discussed issues has been the creation of a permanent or standing mechanism to resolve investment disputes, sometimes referred to a permanent investment court. But what problems is such a mechanism intended to solve, and what are the key questions that still remain open?
I think, yes, I'd probably start out, I guess, as the chair, the rapporteur, the secretary, we don't take a sort of position on whether this will or will not solve problems. So what, I will say is that for a number of delegations who had proposed this work, and particularly on what has become standing mechanisms, both at the first instance level and appeal, they looked at the current mechanism of ad hoc or institutional arbitration and saw concerns with respect to many of the same concerns, cost and duration of the proceedings, the same arguments being made over and over again because there was no overall systemic approach to regulating these disputes. They had concerns with the consistency of the decisions that were being issued on similar fact patterns or on similar treaty language. They had concerns with the correctness of the decisions. And they had concerns with who was making these decisions, with the appointment process, with the idea of party appointment of arbitrators. All of those things they looked, and while some people, as Anna has alluded to, saw areas where this could be done through reform within the system, they thought that the key issues were in fact with the nature of the arbitration system itself. And it was with and what they would say is, in fact, it was not a system. And that was a problem. And so they thought that the really way to change this was to make it a system, where you had a standing mechanism. A standing mechanism which would lead to things like a standing judiciary could be expected to adopt more consistent decisions. A standing judiciary who could be expected, once arguments have been made and decisions have been made, even if there's no formal precedent, one would expect that the same arguments. that could reduce the cost and duration. But they also saw this really as a system of public law, considering state decisions. And for them, the idea that such decisions were being made in a system that was designed originally to handle more commercial arbitration disputes, again, is part of the problem, and that we needed more rigorous, more of a court-like system to resolve what they essentially saw as public law disputes. And so that, for them, was the need to move away from the current structures of arbitration we have to an entirely different structure, a structure of a standing mechanism. In terms of challenges to creation of this, I think there are a number of big issues that still remain. The work is fairly far advanced on these mechanisms and what the statutes would look like. But there's, of course, always a lot of discussion whenever you're selecting or creating a standing mechanism. Biggest question, who are the judges going to be? How are they going to be selected? How are you going to appoint them? And that brings up a number of issues with respect to ensuring diversity on the bench, with respect to ensuring expertise, with respect to considering how it is that there will be understanding of the different perspectives of law, the different subject matters that they may come into contact with. So I would say that has been particularly a focus. Another focus of deliberation, I would say, of course, whenever you're creating a new mechanism or organization, it's the cost of it. How will it be funded? Okay. The same discussions, of course, have been had in the context of the creation of another institution, the Advisory Center, which we have just completed the work on at the Commission. And that is a simple fact of international life. Where will the funds come from whenever a new institution is created? So that has been discussed quite a bit as well. And then once we get away from sort of the first instance, there's been a lot of discussion too about how a standing appellate mechanism interacts with a lot of the current structures that exist. So does it only hear cases from a first instance standing mechanism? Does it also hear cases from the ISDS mechanism? What does that mean if you have an appellate mechanism? Things like the interaction with the ICSID convention, which has provisions saying there won't be an appeal. What does it mean for awards that come out? How are they going to be enforceable? Under what treaties that we have? So there is, in a sense, and I guess this is sort of also creating new institutions. There's an existing, if it's not a system like these, the proponents of this would say, it's at least an ecosystem. It's there, it's got treaties that will work already. It's got, people know their defined roles in that. If you're under the New York Convention, courts understand what they're doing there. You're now talking about plugging an entirely new thing into that ecosystem. And so there's a lot of questions then about how one does that and how will it function in this existing environment. And they've been really fascinating questions to try and deal with. It's not, as lawyers, often, we operate within the court system in which we have in our national jurisdictions. It's not too often that you get the chance as lawyers and as counsel to design an entirely new court system and to think about some of these fundamental questions about, interactions, enforcements, the different bodies. And so I think that's been quite an interesting exercise that the working group has really taken, a challenging one for sure.
Thank you. You're right. I mean, here we're really thinking about creating a new instrument, and with that would work in a system, as you said, that exists already, but has to work in a different way. And as you mentioned, it's not only the investment code, but also the two levels. So it's really a complex situation, and of course, the negotiations for this are still going on. So we talked about the structural change of the investment code, and then the specific part of the specific innovation is a reform of the code. Let's move on with Natalie on more targeted maybe proposals on improving the existing system and looking at procedural and cross-cutting reforms, which I think is also an interesting way to define this. Could you explain some of the improvements that have been considered within the existing ISDS framework? So we call it the procedural and cross-cutting reforms, and they involve issues on transparency, cost, the duration of proceedings, third-party funding, consistency of decisions. Can you guide us? Can you help us understanding what these reform pillar address?
Thanks very much, Chiara. I think it's important to situate this particular stream of work in the context of the existing world and universe of investment treaties, where you've got the older ones that are less prescriptive, and then a series of newer generation treaties that are more prescriptive, but that remains a work in progress. So these procedural rules proposals that are being made are to assist in this guide to tribunals through greater prescription in certain rules. And as you've touched upon, these traverse a range of aspects of proceedings. Transparency is a slightly different bucket because, as Anna alluded to earlier, UNCITRAL had tackled that from 2010 to 2014 and developed the rules on transparency and also its method of application through the Mauritius Convention on Transparency. And the current work is very much focused on making cost and duration of proceedings more manageable. We have a couple about consistency, and I think I would park the joint interpretation provision and the non-disputing treaty party submissions under the idea of consistency. But most of everything else falls under trying to make things more manageable from the cost and duration perspective. Actually, at the most recent UNCITRAL Commission session, 11 of the provisions were adopted. This represents about half of the work on the procedural rules reform, and they were on a series of things: evidence bifurcation, interim measures, manifest lack of legal merit, security for cost, suspension, termination, and so on and so forth. One of them was third-party funding, and maybe a little bit of that because that seems to generate quite a lot of interest as well. The emphasis in the third-party funding provision is essentially on disclosure of information, accompanied by the possibility for a tribunal to take measures such as order security for costs or allocate costs in a particular way, or possibly even suspend or terminate the proceedings in the event a funded party fails to comply with the disclosure obligations, much like the exit arbitration rules from 2022. So these are all useful updates, I think, is the feel of the room at the working group, and also, as we saw at the Commission, 2 procedural rules that are used in ISDS. And hopefully with this work, we can already start seeing some of the amendments, the revised procedural rules being used if agreed by parties, even though there's further work that still needs to be undertaken at the working group, at the Commission, on a further bucket, but also in the way in which these procedural rules are meant to apply alongside other ISDS reform options that we're working on.
Thank you very much, Natalie. Thank you also for reminding us that, in fact, about half of the procedures where the rules have been approved now in the last meeting of the Commission. And in fact, Anna, let me ask you about the advisory center, because another important proposal concerns the creation of an advisory center on international investment dispute, and the Commission finalized and approved the draft statute of the advisory center on international investment dispute just a few weeks ago. And it will now be submitted, I understand, to the General Assembly for adoption. Can you tell us a little bit about the advisory center, but also why has the capacity building and access to justice become such an important part of the reform discussion?
Well, thank you indeed, Chiara. It is going now to the General Assembly for adoption, and just like any other treaty, it will be open for adhering to it. It will open for becoming members of this advisory center. And while the advisory center is open to all member states of the United Nations, it will focus its services, or at least part of its services, on least developed and developing countries. And I'm insisting on this aspect because it comes, if you think about what I was mentioning earlier about the concerns expressed about ISDS, there was, when talking about the legitimacy of this ISDS system, a perception of inequality of arms between least developed states and, for example, big investors, big multinational companies that have deep pockets, that have strong legal teams assisting them, and then small countries that do not have either the need nor the luxury to have an in-house team of dedicated lawyers, maybe like the one Shane has been leading for many years, where they had over 20 lawyers working on Canada's investment claims. For small countries in Africa, especially least developed countries, this is not the case. So the aim of the advisory center is really to tilt the balance back, to reestablish some balance between defending states and claimants, and provide these states with capacity building to allow them to have a better grasp at preventing disputes, at finding alternative routes for disputes, at managing the disputes when they come their way, instead of forgetting the notice of intent in one of the drawers and then 3 months later saying that a tribunal has been constituted in their default. And on the other hand, also providing what is important for these states, the possibility of representation services. So you really have two pillars in the services this advisory center will provide. One, which is the capacity building in a very broad sense, technical assistance, implementation of treaties, implementation of the reform, of course, as well, which will be open to all member states. And then more specific services that can go up until representation services that will be available to least developed countries as a priority and developing countries. So this is really what this advisory center will provide. It's very similar to what exists in the WTO, where you have an advisory center for developing and least developed countries that is really meant to restore an even, or to establish an even playing field. And this is very much what the working group had in mind, that to make it more balanced and to also make it more efficient, because at the end of the day, when the state is well represented or well assisted and responds in time, it makes the system work.
Thank you. Natalie, kind of in the same vein as the advisory center, I think we also see work on mediation and dispute prevention. Working Group 3 has considered investment mediation and dispute prevention really as important elements, and has already approved some reform. Could you explain why these issues have become part of the reform discussions, and what role can mechanism aimed at preventing disputes or facilitating early resolution play in improving the ISDS system?
Certainly, Chiara, I'm very passionate in particular about this aspect of the ISDS reform work. And it was really heartwarming to see that some of the first approach alongside the Code of Conduct was also on mediation. So UNCITRAL produced, through the work of Working Group 3 in 2023, the model provisions on mediation. There were also guidelines on mediation and international investment disputes. And then in 2025, the toolkit for prevention and mitigation of disputes followed. This was in addition to earlier work by UNCITRAL, not in Working Group 3, in another working group on the Singapore Convention on Mediation, which is also applicable in the ISDS context. And how did all of these come to be in relation to the work on ISDS? In essence, my view at least is that reading the room, the value of dispute prevention in ISDS and our investment mediation was appreciated. In respect of dispute prevention, that overall it's more desirable to address a dispute at its root, to facilitate investors and state communicating and working with each other over challenges that they may encounter, even before a dispute even crystallizes. And dispute prevention methods can also be used to avert further escalation of a dispute. And as for investment mediation, it has a few valued characteristics, quite a few, and I think I'll just touch on two in the interest of time. For one, there is flexibility and autonomy in how mediation processes and outcomes can be designed, and this achieves a number of things. First, efficiencies, and that goes to cost and duration. Second, the accommodation of stakeholders, such as interested members of the public, which goes to legitimacy, quite critical in the investor-state context. And third, because disputing parties can design their own solution to the dispute, this often means greater buy-in from both sides, better ensures follow-through in the implementation of the solution and the settlement outcome. It's more sustainable, and also for states being able to be part of designing the solution to the dispute then avoids that sensitive question of who the decision maker is regarding issues that might concern the right to regulate and other policy functions, and that also goes to legitimacy. So that's one, the flexibilities in the process and also in the outcome. In terms of the second bucket, I would say two, with investment mediation, disputing parties can explore matters beyond what initially triggered the dispute. And so in this way, mediation is better suited to dealing with often the complex and multi-issue nature of investor-state disputes that often engage social interests and environmental interests. And it means that the solution to the dispute can be more holistic, goes beyond the mere payment of financial compensation. And further, such an approach orientates your disputing party so that they're trained on the future rather than on the past, and have the opportunity and incentive to repair their relationship, in contrast to the adversarial dispute context where focus is on merely liquidating that investor-state relationship. And I've put it in my own words, but I do think these were at the heart of what was appreciated by delegations in the room. And it was the individual delegations in the room, they had written papers, but also in their oral comments, brought us to the work on mediation and made sure that it remained a key tenet of the work as we continue to progress on it.
Thank you very much, Natalie, for this excellent overview. Shane, to conclude this part of the podcast, looking at the reform proposals. Now, the working group has also been discussing a possible multilateral instrument to implement all of these reforms across existing investment treaties. Can you explain, well, first of all, why such an instrument may be needed, but also what it entails? Why is reform through a multilateral approach attractive compared maybe with individual treaty renegotiation?
Thanks, Chiara. And I think throughout all of this, we've taken on ourselves a very broad mandate for, I think, as to what, and I said, a very deep reform of investor-state dispute settlement. But one of the things that we were cognizant of, really actually back to some of the work that Anna was talking about with respect to transparency, was the system of treaties that we find in the investment context is not one big multilateral treaty where you can get the parties together and try to amend it. Instead, it's this diffuse network of over 2,000, 3,000 investment treaties that have sort of grown up organically. There's a lot of similarities, but you've got bilateral treaties, plurilateral treaties, some multilateral treaties. And they've all contributed to what is this current network of treaties. So when we talk about adopting reforms, but the biggest question then becomes, how does one effectively implement reforms? Because you can do great things in terms of the substance of what you do, but if you don't actually change the underlying treaties in the investment treaty context, then you're not actually effectively making changes. One of the challenges, and it does relate to the bilateral nature of a lot of these relationships, is to get states to extend the resources necessary to go and amend individual treaties. That can be very challenging, particularly for a lot of these treaties. There aren't many disputes pursuant to them. Some of them exist, but of course, you only need that one big dispute under a treaty that might come up in the future before it becomes an issue if you haven't adopted modernizing and important reforms. And by the time the dispute comes up, then it's too late to turn to this. And so right from the very beginning, we knew that we needed to have a mechanism to implement this, which is why I think Anna referred at the beginning to some of the work done by SIDS and others saying, could one use the technique that we had for a multilateral convention in the transparency context to be applied more broadly, looking at standing investment mechanisms, but this idea of how do we have a multilateral treaty, which essentially requires a state to have one signature on the treaty, one event that they go, one signature they sign, one ratification to process, which as long as there are other treaty partner sides on, allows them to benefit from these reforms. And I think that is one of the more significant innovations in tackling one of the challenges that a lot of people had for years said makes the investment treaty system somewhat immune or difficult to reform because it's this diffuse network. Having that mechanism to do that allows us to tackle that problem, to say, okay, now there's one signature you have to apply, and you might have to opt in between different types of protocols and annexes. You might have to make more than one decision, but it is one decision-making instance that you have, and that's been very attractive to states. And I think that's the key for why we've all seen this at the end. To affect these past treaties, this existing network, we have to have this broad multilateral instrument, which will be crucial. And the success really of the whole reform effort is going to somewhat be reflected in the participation in that instrument for states to change their existing treaties.
Thank you. Thank you, Shane, Natalie, and Anna for this excellent overview and for explaining the reform proposal. Let's now change focus and briefly look at maybe the big picture and maybe major achievements so far. Anna, looking back at the work completed so far, what do you identify as the major achievement of work in Group 3?
There's several that I would like to emphasize, but I would say the most important, the most interesting, and the most heartwarming is to see this common understanding of states that something had to be done, states and observers, as Shane and Natalie also rightly noted, that something has to be done. And so there is a kind of general goodwill towards this reform. Of course, it has its ups and downs. Some countries are more amenable to certain types of changes, are championing some and others. But over the years, we've seen really a movement of common understanding. And the other, I would say, is the coherence that is being kept in spite of having to deal, as Shane rightly explained, spaghetti bowl. You know, we always use this image of the spaghetti bowl when talking about investment treaties, because it's really a mass of spaghetti that cling and that are interconnected. And what the working group is really doing is bringing some sauce, some seasoning, some gravy into this bowl to make this bowl more coherent. And from the beginning, we had been looking at this as designing a reform. I always use this image of the little house, you know, where you had really this two layers, these two floors. The first floor, the entry doors into the ISDS system, and then the appellate for working for different entry doors, and then the support to the states that we explained, that we talked about with the advisory center, these very important alternative methods that Natalie explained. All of this is coherent. All of this works together, and the way it will be delivered that Shane just highlighted, which is through this multilateral convention, is really going to make it work, or at least workable and coherent. And I think if I should say, if you wanted to have two words to summarize, I would say common understanding and coherence, definitely.
Thank you. Common understanding, coherence. That's a good conclusion so far. Natalie, from your point of view, from the perspective maybe looking at the arbitration community and the users of the system, have you seen any changes? What has changed already? Are you seeing changes in practice even before a final reform package is adopted? We discussed the code, for example, and how that has impacted and other reforms. What have you seen in terms of the users of the system?
Thank you, Chiara. Yes, indeed. As Anna mentioned, the code she's observed has already been consulted in practice by arbitrators. And I think generally the arbitration community has come to recognize the need to respond to the criticisms being levied against ISDS, and they have for some years now. So we do see that tribunals do utilize the early dismissal mechanisms that they may have at their disposal, or order security for costed proceedings, for example. They're more cognizant across the board about the need for active case management, but there also needs to be a treaty basis for some of these changes to happen. And then we have seen changes and shifts over the years too, in the way modern investment treaties have been drafted, for instance, to already include provisions of bifurcation or counterclaims. These don't necessarily trace to the work at Working Group 3 specifically, but I think it has been generated in some part by the attention and the discussion and the deliberations that have been taking place at Working Group 3 that have increased the awareness of the issues across the board and more generally. Speaking primarily as a state user of the system, already states are taking steps to reform ISDS in their new generation treaties. And here I would like to bring in the specific work of Working Group 3. There has been adoption of the work product of Working Group 3.0 as it stands, even before the full package has been developed. So, for example, we heard at one of our working group meetings, the Canadian delegation shared that their one of the investment treaties, or I think two of them by now, refer to the Code of Conduct. I'm also aware of how steps have been taken in the context of other treaties to refer to the UNCITRAL model provision on mediation. And all of this is positive. All of this is to be encouraged. In our working group discussions on ISDS reform, there has been importance placed on having reform take place quickly enough. And there is a sense of urgency on the part of delegations, and this has contributed to the openness towards some element of our reform project already getting underway, being adopted in practice, even before other elements have been fully developed for implementation.
Thank you. Shane, maybe a broader question now to you. One of the remarkable features of this process is the states with very different views on investment protection have remained very much engaged. What do you think explains this ability to continue the conversation since 2017?
Thanks, Chiara. I think, we have been quite successful in maintaining the intention and the interest of states, and it's been rewarding each time to arrive and see it's the same number of states, even more so sometimes, that continue to come. Both, of course, there was the pandemic in the middle, and one wondered what would happen after, but we picked up right after with in-person sessions, same amount of participation. And it's great that we see, as you say, participation from developed countries right down to least developed countries. I think I would say, I guess, a couple of things. One is obviously it's the importance of the work and the importance of the system for states. They do recognize the significance of this system. And therefore, there has been a global consensus on the need to reform it. That was part of the work that the working group did. And so they understand the importance of the work that's done. I would say second is, as pointed out by both Anna and Natalie just now, they are starting to see results. We are producing things that they are both using in their future treaties, but they also, they see that we're actually producing some outcomes for them that matter. And I guess the third that I would say is, I think in terms of the diversity of the participation, they really do see UNCITRAL, particularly for maybe states who in individual negotiations wouldn't have as much negotiating power, as a place where they do have a voice, where they do have the ability to come in and present their point of view and also be heard on that, and be heard and have their experience considered. And I think that has really been a major factor in continuing to drive the interest in the working group, is the environment in which we operate and how we operate that environment to ensure that all voices are heard and that no state is left behind. And that's been, I think, a driving force of the participation. And I will say as well, it has almost come into itself a forum where states do get to have some of these discussions about what is going on at ISDS, such that some states have said to me, and I'm sure to Anna and Natalie afterwards, so when Working Group 3 ends, how do we continue this conversation? Like, how do we make sure that a forum like this continues to exist? Of course, we have the advisory center now, which foresees this, but that was one of the big things. I think states have seen an advantage as well to just being in the room, not just participating in the discussions, but being able to interact with their colleagues, learn from each other, talk to each other about what's going on. So it's had not only the effect of creating a forum for actual technical work on the reforms, but creating a forum for conversation and a much softer way of exchanging between governments and states and learning, as well as observers and learning from each other. And I think states have also really appreciated that opportunity.
Thank you. Alison, our time is almost up, but I wonder if I can ask you two very quick questions to all of you. Maybe if you can reply in a minute or so. The first one is about the way ahead. And Shane, let me ask you first. What do we see? So where the process stands today? You mentioned the desire of other of the parties of the states to be involved. Looking ahead, where do you see the biggest challenges, and where does the process stand today, and what are the next steps? And I will ask the same question to Shane, and then Anne and Natalie.
Sure. I think, obviously it continues to remain a challenge to ensure that everybody does continue to get engaged and to try and find the consensus on some of the, areas where there isn't as much before. We referred to, code of conduct, some of the reforms that we've done, it's low-hanging fruit. They weren't easy to negotiate, but there was a fair amount of agreement that they were in the room, that they were important reforms. We are now talking about some of the challenges and reforms where the room is much more divided in terms of the structural reforms as to whether or not these will address or help in addressing some problems. So keeping the coherence of the room, keeping the ability of states to continue to participate, I think that will be a challenge. And in any process, of course, as we move towards the end of this, and we are moving towards the end of it. I mean, we've been going for 10 years, but I've been telling delegates for a while that we see the light at the end of this. Like we are in the final stage of this. And as anybody knows, when you're in the final stage, keeping the momentum up and ensuring that we don't get sidetracked by what maybe things that will not pay off in the end, and keeping focus, long process like this, keeping the attention, keeping the focus, and keeping the momentum going so that we can finish on in line with our time frame as to when we can develop these reforms, because we have to keep that sense of urgency going. Cases continue, new treaties are being signed. This is a project that has to come quickly as possible to a conclusion, while ensuring that balance, that nobody gets left behind and that people can understand and be ready to adopt reforms in the end.
Thank you. Natalie, the same question to you. What's the way ahead?
I certainly agree with what Shane has mentioned, that the two main things that we want to be able to do is to maintain that momentum for consensus and also to make sure that we finish. I think what we need to appreciate is that a lot of what we're doing now in this final stretch involves the finer details of system and institutional design on some very potentially quite far-reaching reform. So we do need to keep our big picture hats on, but at the same time, we cannot lose sight of those little details whilst we've got to strike that balance between getting the work done efficiently and effectively, but also not skipping over the important details that might trip us up. And it's always been about that. It's always been about maintaining that balance through the process, and it's never been more critical to continue to ensure that this is done, as Shane mentioned, as we move into this final stretch.
Thank you. And Anna?
Well, I'd like to emphasize what both Shane and Natalie said, which is that we are reaching the end, and it seemed quite far and quite difficult to achieve, but we are now in the second reading, I think, of the appellate tribunal. We are in the second or third reading of the first instance court. There's been a lot of progress on the cross-cutting issues, the so-called cross-cutting issues that are really important for some from states in the room, particularly, for example, the calculation and assessment of damages, which is one of the big criticisms or main defects of the system of ISDS, where there's basically the sky is the limit. And there, the texts are advancing. So there is both this push to move forward, and the still not losing sight of the fact that at the end, states will need to make their choices. So there are options at different levels. There were options at what is it that we want this working group to be working on. Pick and choose. They could pick and choose, and then there will be different instruments, different texts, different institutions that they can pick and choose from. And then they will also have to pick and choose the treaties that they will want to submit for reforms. Some of their more recent treaties may be more favorable than what will come out of the ISDS reform in UNCITRAL, because they have the benefit of a bilateral negotiation among pairs, for example. But the others is really to make sure that these two remaining levels of choices are understood and are also implemented, so that the states, once this is done, know that there's still something for them to do. And as we know from experience, it takes time for states. You know, I always say there is the time of man, the time of God, and in between is the time of states. States need time to join a convention, need time to ratify. So all of this will need time. So if we want to have something out there before the next coming 10 years, there is an urgency.
Thank you. Then before we close, I'd like to ask each of you a more personal and maybe a reflective question. The Working Group 3 has been a remarkable exercise, as we've heard, in multilateral lawmaking. It has been quite a journey, 10 years. It has involved states with very different perspectives, a wide range of stakeholders, and the process requiring both technical expertise, but also some political judgment, At the same time, each of you has approached this process from different positions. Anna from the UNCITRAL Secretariat, Shane coming from Canada as chair of the working group, and Natalie coming from Singapore as a rapporteur of working group. How have you navigated the relationship between your institutional responsibilities in guiding the process and also your role as maybe representative of your countries and your personal also takes? And more broadly, after several years of working on this reform effort, what has this process taught you about the possibilities and challenges of achieving consensus in international law? Can I ask you to be brief, maybe 1 minute each? Can we start from Anna?
So for me, in my role as the Secretary of UNCITRAL and the broader role of the Secretariat, it's really to create and to maintain a forum where they all feel it is their home, it is their place. This is where they can, all of them, be welcome, be informed, be trained. We did a lot of webinars, outreach, promotion, to really make sure that the delegations would come to these negotiations well prepared, well informed, well motivated, and I think that is really where also the secret of this multilateral, successful multilateral process. I'm not saying outcome because I don't have a crystal ball, but at least a process is that all states feel at ease. They feel that they belong, that it is theirs, that they are supported, that they are heard, that their voice matters. And I think that is a way of building this necessary consensus that the working group has achieved by, Shane's chairmanship, Natalie's strong rapporteur support, and the work of the Secretariat.
Thank you, Shane. Your final reflections?
I think in terms of one of the initial challenges was making sure that, probably for Natalie and I, that we were acting in a role that was very specific. We weren't representing our countries. We didn't, and I think we kept that very sort of clear. We kept a wall. So, I don't know what Canada's positions will be in advance. I will speak to the Canadian delegation like I speak to any other delegation. I think that's also been important for everybody in the room to understand the neutrality that we have on things. And that neutrality for me also extends to, I like to say this sometimes too, we may have views, or I may have views on what the right or the wrong answer is, but they don't get to know what those views are because that's not my role. This is not a seminar where we're trying to teach what the right answer is. I think what I've really learned and experienced is the role that I occupy or is a facilitator, right? We're trying to facilitate the finding of consensus amongst states. And there may be times when we may look and say, not sure I would have done it that way, but that's not, our role to sort of correct, unless things are going to, as this gets to Natalie's point, unless it's really not going to work, unless we see like a technical problem. But in terms of the substance, I think that's been the most sort of fascinating thing to watch in terms of the multilateral approach, which is, it is hard. It is different viewpoints. You're trying to come to consensus amongst people with very different experiences of the system. And to be able to try to find a way just to bring out the common themes, bring out the common points so that they can begin to see the similarities between where they might need to go as opposed to just focusing on the distances. I think the difference, that's been the sort of the most interesting experience in this multilateral aspect so far.
Thank you. And Natalie, your final reflections on the experience of multilateral lawmaking?
Well, first of all, Chiara, I don't think I say it enough. It's a heavy responsibility, but it's also an immense pleasure and privilege as rapporteur to work with Shane and to work with Anna, Jane, Neil, and the Secretariat team to ensure a well-run process that's fair, that's inclusive. And as Shane mentioned, while we bring our own perspectives as government representatives from our respective countries and regions, these perspectives are not intended and should not supplant the need for proper dialogue in the working. And what I've seen through the last 10 years and through other multilateral processes made me only feel it stronger, that consensus does take time, but the time to arrive at a real consensus is worth it.
Thank you. And to wrap things up, thank you again to our guests for such an interesting discussion. I really enjoyed our conversation, and I hope our listeners have too. A reminder that you can join us on the first Monday of every month for more international law chats. And as always, thank you also very much for our amazing podcast producers, Laurie Farid and Freya Doughty Wagner.